Over the weekend, the special counsel Jack Smith made an urgent holiday plea to an appeals court to keep the ex-president's gag order in his federal election interference trial, pointing to the latest real-life evidence of threats and harassment stemming from Trump's continued online rampage against courts and judges. Special counsel included in his letter sent on Thanksgiving Day the copious, vile threats in the separate ongoing civil fraud trial in New York, including the quote, hundreds of threats, disparaging and harassing comments, and anti-Semitic messages that are directed at the judge and his staff, end quote. Joining our conversation is a former top official at the Justice Department, Andrew Weissmann. With me on set, MSNBC legal analyst Lisa Rubin. Welcome to both of you. Thank you both for joining us this afternoon. Andrew, let me just start with you. Tell me about the connection, for anyone who doesn't sort of understand the legality of this, of Jack Smith using stuff that's related to the New York civil fraud trial for his own trial.
Sure. Well, you have two judges, one in a criminal case in D.C. and one in a civil case in New York, dealing with a similar issue, which is that Donald Trump is a defendant and he is speaking in ways that the government thinks, and the court has agreed, the trial court has agreed, endangers the integrity of the judicial process. That judicial process can be a civil case, as in New York, or a criminal case, as in D.C. Now, the gag order in D.C. was much broader. It related to the court and the court staff, but also to Jack Smith and his staff, and to jurors and witnesses. The New York gag order was very limited. It related to the court staff, and particularly about not speaking about one particular principal law clerk. That was something that the judge said was prohibited. Both of those so-called gag orders are on appeal, and both are stayed pending appeal, meaning that they are not yet in effect pending the outcome of that appellate process. But the reason they relate to each other is the history of violence, the history of threats to witnesses, potential jurors, to court personnel, to prosecutors is relevant to both cases. In the same way that Judge Kaplan, a federal judge in the E. Jean Carroll case, has already taken steps to protect the jurors in that civil case because of the concern of prospective violence towards jurors in that case.
So let's discuss it, because Lisa, this becomes a broader issue of a permission structure that gets created that can not just be intimidating for witnesses, but we're going to talk about this later in the show, that's also just part of this growing sort of environment of violence and hate. From the document cited by Jack Smith, written by a court employee in the New York fraud trial, it reads, I've been informed by Ms. Greenfield, Judge Engoron's principal law clerk, that she's been receiving approximately 20 to 30 calls per day to her personal cell phone and approximately 30 to 50 messages per day on combined sites of social media, LinkedIn, and 2 personal email addresses. Ms. Greenfield also informed me that since the interim stay was issued lifting the gag orders on November the 16th, 2023, that Andrew was just talking about, approximately half of the harassing and disparaging messages have been anti-Semitic. The reason I bring this up is because this is not about witness interference in the, or court interference in the normal way. It's this permission structure of harassment and intimidation and anti-Semitism.
Yeah, and you can see that, Ali, also in the affirmation from the court officer, because in addition to excerpting some of the most vile threats against the principal law clerk, which primarily have to do with her relationship with the judge and her religion, encoded in those are also threats against Letitia James, who's the New York Attorney General, that take on a very transparently racist nature,
right,
and also threats against the judge, who himself is Jewish, and therefore those are anti-Semitic. And there's also a suggestion of homophobia. It's not just a suggestion. There's more than a whiff of it. There's some real homophobia in those threats, too. So when you talk about an environment of hate, it is sort of a cataclysm of isms, so to speak, in that affirmation. I think the reason, though, going back to the conversation you and Andrew were having, one of the reasons the special counsel wants to bring this to the D.C. circuit's attention is because there was a suggestion during oral argument that there was no proof that anything Trump had said had led to particularly violent threats against anybody who was a subject of that gag order. Obviously, someone has been arrested for threatening Judge Tanya Chutkan, but she herself is not a subject of the gag order she issued that is now on appeal in D.C. By giving to the D.C. Circuit this affirmation from the court security officer in New York, you start to see evidence of what happens when Trump issues a threat, both in kind and the extent of that. One of the things you didn't mention about that affirmation is that the court security officer says, I've transcribed the voicemails that have been left for Judge Engoron and his chambers and for the principal law clerk. They fill 275 single-spaced pages.
Wow.
To dimension that like that, particularly when the D.C. Circuit doesn't have evidence like that at its disposal, in large part because some of the people who would be witnesses in that trial don't have a law enforcement apparatus supporting them, right? They're private citizens now. So to give that information to the D.C. Circuit, I think is particularly valuable to show there's not just a correlation between a Trump post and an uptick in a threat environment, but you can actually quantify that and excerpt it and present it to a court in an evidentiary fashion.
Andrew, is there a Fifth Amendment defense here to say, sorry, that people have nasty, homophobic, racist, anti-Semitic things to say to court officers and others, but it's got nothing to do with the trial at hand?
Well, it's not a Fifth Amendment, but I think that what you do have is
I said Fifth Amendment. I meant First Amendment.
Yeah, I was going to say, so Donald Trump has raised a First Amendment defense in both courts. And there's sort of two answers to that were discussed in court. One is that this is not a restriction on you and I. This is somebody who's in the court system. So this is really about bail restrictions. And remember, when you're out on bail on a criminal case, there are all sorts of restrictions. You have to report to pretrial services. You could have to call in. You could have travel restrictions. My word, you could even be under house arrest or even jailed pending appeal. So there are all sorts of restrictions on rights that you otherwise would have. And what the court in D.C. was particularly interested in is what kind of prophylactic steps the court is entitled to take in order to make sure that there's integrity to the judicial process, that people feel safe, that they will come forward and testify truthfully without fear of being harassed or worse. And then, of course, as Lisa pointed out, there is this issue of causality, the call and response that we see time and time again with the former president. And in fact, he is in many ways charged with that in connection with the January 6th DC case. It is a call and response that we have seen so many times, and that the court is going to assess here in deciding the parameters of a gag order. And I think the general view is that the D.C. Circuit is likely to affirm the gag order, at least in part. They may restrict it around the edges, but that they are going to be concerned about, at the very least, witnesses and jurors, maybe a little less concerned with people who are court officials who have extra protections at their disposal. Although I will say that's still a hard thing to explain to the public, why court officers should be subject to this just for doing their job.